In this final podcast for Module 4, we're going to be looking at how people can draw up agreements. And this is in the context of they've reached agreement about their children, either through negotiations themselves, negotiations through lawyers, at the end of a mediation, or they can even do this while there are proceedings in court. So even though they've filed a court application, they might along the way reach agreement and want to draw it up and file it in court. So in this podcast we're going to be looking at the options that parents have if they reach agreement. So the different options they have in the way that they can draw up that agreement. And obviously too, they don't have to write up the agreement formally. They could keep it as an oral agreement, and there are many parents out there in the community that do this. And that's fine, provided that they're both prepared to abide by the agreement. We'll look at the types of agreements that can be drawn up and the advantages and disadvantages of the different types. Now, for example, say you're at a mediation with your client, they've reached agreement with the other parent. How do you draw up this agreement if they want to make it more than an oral agreement? Now, usually at the end of a mediation, or in any other context that we just discussed where people might enter into an agreement, it is good for people to have a record of what they've agreed to, just so both parents are clear about what they've agreed to. And often in parenting arrangements you can have quite lengthy agreements running for pages and pages with many paragraphs. It might not just cover, for example, the time the children are to spend with each of their parents, can also cover a whole range of matters from the time they spend with their parents, how they're going to change over between their parents, then also what's going to happen on special days such as Mother's Day, Father's Day, birthdays for children and parents, what's going to happen in the school holidays if they're at school, what's going to happen at Christmas, the other special days that parents might want to celebrate such as Easter or other types of religious holidays. It can also cover things like allowing both parents to access school reports, be present at school events, sharing of information, re-education, and also sharing of information in relation to health. So that's some examples of the types of things that can be included in an agreement. Now, when you're drawing up an agreement, you could just write it up as dot points. That's a very informal way, and for example, if lawyers do it this way, they usually call it heads of agreement. And it's really the same thing. You just have a title, heads of agreement, and then dot points summarising what the agreements are. More formal ways of writing up an agreement in a parenting case are either a parenting plan or a consent order. And we're going to have a look at the differences between these and the advantages and disadvantages. Now, a heads of agreement can be perfectly fine if people don't want anything more. It does make clear to people what they have entered into, and it gives them something to take away. Also, often new partners, relatives are very important to parents, and they also have that written agreement to be able to show to their significant others. Now, another option is a parenting plan, which is a more formal way of drawing up an agreement. The requirements of a parenting plan are set out in the Family Law Act in sections, for example, 63. So it would be good if you have a look at these provisions while we're talking about them, and we can open them up while we're looking at them. So go to the Family Law Act, and we're going to the Family Law Act now so you can follow us through. And we're looking at, sorry, I'm just going back to the right section, section 63. So just going to the right section, you will see that there's a whole division here on parenting plans. Now don't worry about the parts that talk about registration of parenting plans. That was what happened many years ago and is no longer relevant unless it's a very old parenting plan. So we're just going to look at, for example, 63B, that encourages parents to reach agreement to use the legal system as a last resort. And this really gives, I guess, the underlying philosophy of people reaching agreement themselves and writing up a parenting plan. So have a read of that section. Then we also have section 63C, which actually sets out the formal requirements for a parenting plan. Now it says to be a valid parenting plan, it must be in writing, it must be made by the parents, signed by the parents and dated. If it doesn't have those requirements, it's not a valid parenting plan. However, a parenting plan is not filed in court, so that's something important to understand. However, it is a formal written record of the agreement reached in relation to children between the parents. Now another requirement is that the parenting plan cannot have been made by threat, duress or coercion. For example, one parent feels that they have to agree to certain provisions because the other, for example, the other parent may take the child away from them if they don't agree to those provisions. Then this subsection 2 deals with what sorts of matters a parenting plan can deal with. So have a look at that. Time children are to spend with parents, allocation of parental responsibility, communication children will have with their parents when they are not staying with them, maintenance, that's for an adult child, the process parents can use to resolve any future disputes. For example, if issues come up that they can't resolve in the future, it might set out that they attend mediation at a community mediation centre. And any other aspect relating to the care, welfare or development of the child. So that gives you a general idea of the requirements of a parenting plan. Now there are obligations, and we've got, actually on that slide we've said FDRPs, obligations surrounding parenting plans, and I should have also said there also family lawyers' obligations surrounding parenting plans. So in section 63B, it is for us as lawyers, and if we become family mediators, to focus parents on reaching agreement that are in the best interests of their children. And that really means taking into account their children's ages, their personalities, their developmental needs, the activities they're engaged in, their education, and really focusing on what might be in the best interests of the child. Not meaning that parents can't also take into account their own work arrangements, their own commitments to new partners, new families, etc., which of course has to be the case. And then there is section 60D, which as lawyers and family mediators we have to bring to our clients' attention. So have another read of section 60D. It says we have to advise our clients that they should regard the best interests of the child as the paramount consideration, encourage our clients to act on that basis, and also to advise our clients that their best interests are served by having a meaningful relationship with both parents, provided that they will be safe and protected from harm and will not be exposed to physical or psychological harm or abuse, neglect or family violence. Also, when looking at those sorts of considerations, giving more weight to protection from harm than meaningful relationships. So that's one of our obligations, is to explain Section 60D to our clients. The other obligation is to explain Section 63DA. Now, Section 63DA was inserted into the Act in 2006, and then Section 60D was inserted into the Act in 2011. So to some extent, Section 60D has overridden Section 63A in that arrangements must be in the best interests of children. However, the obligations set out in Section 63DA mean that as family lawyers we must advise our clients that they can consider entering into a parenting plan, and we'd have to say, even though it doesn't say this in the section, if it's appropriate in the circumstances, because it may be more appropriate that they enter into a consent order, and we'll talk about consent orders in a minute. Also, it says that advisors have to talk to their clients about whether it is in the child's best interests and reasonably practicable to have an equal time arrangement or a substantial and significant time arrangement. Now, I have to say the reason that Section 60D was inserted into the Act in 2011 was because of concerns that family lawyers and family mediators were emphasising this section about considering equal time and substantial and significant time, and not prioritising best interests of the child and also protection from harm. So these sections have to be read with Section 60D, and we would only really advise a client about these sections if it was appropriate in the circumstances for them to consider equal time. For example, we will look in our social science module at the social science research that gives us guidance about when an equal time arrangement may be appropriate. And also the research shows us that often equal time only works well when parents are able to cooperate and collaborate together, which are often not the types of parents that are approaching lawyers and having to go to court. So we'll talk about that in more detail in our social science module. So a key aspect of parenting plans is that they're not filed in court. They're therefore not, I guess, in a sense, strictly legally enforceable. However, they can be taken into the court if, for example, the agreement breaks down and one party makes an application to court. The court can have regard to that previous parenting plan. Also, if a parenting order is made by the court and then circumstances change and the parents enter into a subsequent agreement and write that up as a parenting plan, that parenting plan will override the court order. The reason for this is that arrangements in relation to children often have to be quite flexible and fluid. They often change as children get older and also as parents' arrangements change. For example, they might get a new job, they might have to move for a new job, they might have a new partner with new children and want to have the time a child spends with them line up with when their new partner's children stay with them, all that type of thing. And as children get older, they might be seeking to change arrangements so it fits in better with them. So I guess you can see the advantages of parenting plans are that they're flexible, they can be changed easily. You can write up a parenting plan today, and then if in 2 weeks circumstances change and the parents agree, they can write up a new parenting plan, and it doesn't have to be filed in the court. They just each keep a copy of the plan that has been signed and dated by them. In contrast, A consent order is a different type of agreement that we draw up. It is filed in the court, and the court has power to approve a consent order under Section 81J of the Family Law Act. If people have never been to court or filed an application, they can file a consent order with an application for a consent order. If they've already got proceedings in court, they can, for example, hand up a consent order to a judge at a mention, and the judge then approves the order, or the registrar approves it in chambers if it's been filed without any previous proceedings, provided that they're satisfied that it is in the best interests of the child. It will be a binding order once it is filed in the court, approved by the court, and issues from the court with a formal court seal on it. Now, these days there are a lot of what we call litigants in person, or self-represented people that don't have lawyers. If they're wanting to draw up a consent order, there is a kit available, and I've just given you the link to that kit if you want to have a look at it. There are special provisions if, for example, people want to make a consent order and it involves a non-parent. Now we'll just have a look at the family law rules regarding consent orders. So it's Rule 10.15. It says a party can apply for a consent order orally if you're already in court, or by lodging a draft consent order, and that means there's no prior court proceedings and you file it in the registry of the court with an application. Subsection 2 says it must set out clearly the orders that people are seeking, state it is made by consent, be signed by the parties, and I guess it has to be clear that the parties are both agreeing to it. Now, if a consent order is wanting to involve a child living with a non-parent, or a child spending time with a non-biological parent, and that this can occur, for example, where there's a step-parent, the court might want some extra information in relation to that. Special conditions that need to be followed if a consent order is filed in a court purporting to provide that a child lives with or allocates parental responsibility to a non-parent, that is a non-biological parent. The most common instance would be a step-parent. In that case, the court cannot make the proposed order unless the parties have attended a conference with a family consultant, and subsequent to this the court is satisfied that it is appropriate in the circumstances to make the proposed order. Now, if you're advising a client whether they should enter into a consent order or parenting plan, you have to really take into account the circumstances. The advantage of a parenting plan is that it's fluid and can be changed easily, and it's often appropriate where people are entering, for example, into a temporary arrangement. Say, for example, it's a very young child and one of the parents hasn't spent much time with the child, and they're going to just start off with an arrangement and see how it goes. That might be a good agreement to put into a parenting plan. On the other hand, if the parties have been in very high conflict, say your client is very concerned as to whether, when the child visits the other parent, as to whether they will be returned, it might be appropriate to enter into a consent order, because that's filed in court. It is strictly legally enforceable. For example, you can go back to court to enforce the terms of the order. However, in relation to a consent order, it is much less flexible. There is what we call the rule in Rice and Aspland, and that is explained in these paragraphs of the text. What it means is that if you're going back to court wanting to have the court approve an amended consent order within a short time of filing the original consent order, the court will not be prepared to approve the subsequent consent order if there has been a substantial change in circumstances. Now, in the text in 5.230 in Edwards and Edwards, the full court of the family court stated, the well-settled principles in Rice and Aspland were formulated to promote the best interests of children. They recognise the damage which can be caused to children by endless litigation, which may, directly or indirectly, expose them to conflict and the potential abuse of a child by subjecting the child to repeated expert interviews. So I guess the idea is that if a consent order is entered into, that it is reasonably final, and unless there's a substantial change in circumstances, that the court will not be prepared to change it. It's also set out and explained in 8.330 of the text, and it says that in that case the full family court stated that a court should not entertain an application to change parenting arrangements lightly, as a change is always a factor in human affairs. The applicant must establish a threshold issue that there is a new factor or change in circumstance. The court should consider whether the introduction of new material would lead to a different result when considering the threshold issue. So that's something to consider if you're wanting to draw up and file a consent order. It's not a flexible document and it cannot be easily changed. Now, some good references in this area. We do have a CCH online service in our QUT library database under law databases, and we do also have an online family law guide. And we also have two texts, Practicing Family Law, and these should be in the library, and the Marie Livermore Family Law Handbook. And I think the Marie Livermore book has been updated and there is now a third edition, which I think, it is available in the library, so that should be a third edition, and it is a later year, and sorry, I'm just looking for my copy, but I just can't find it to tell you the year, but it's definitely available in the library. Okay, well that ends our series of podcasts for Module 4. I will put some examples of parenting, an example parenting plan, or a precedent for a parenting plan, that is a template, and also a consent order on the Blackboard site.